Hello, everyone, and welcome to the channel. I'm very glad that you're here with me today. Today, we're going to discuss one of the most important principles of effective drafting. How can we bring clarity to contract drafting? As you know, lawyers spend a tremendous amount of time and effort drafting and negotiating a contract. Imagine what if they discover that there was a single unclear sentence that could cost your client lakhs of rupees. On this note, we could also say that contract disputes could also arise not because the lawyers then didn't know the law, they arise because the drafting wasn't clear. This is why clear drafting matters, as there are potential business, legal, and financial risks involved with unclear language. This will be our focus today. And on this note, we will look at some practical tips in the session that you can use to prepare stronger and more effective documents. So, what exactly do we mean by clarity? It means every clause, term, and condition should be written in a language that is easy to understand and they leave little room for different interpretations. As you draft each provision, you can ask yourself one very important question: is this clear? So, when there is any possibility that someone could interpret a clause differently from what you have intended, it should be revised. So imagine that you have spent numerous days drafting and negotiating a software agreement worth lakhs of rupees. Both parties have signed the agreement, and in coming months, maybe like 6 months later, a dispute arises. It is not because anyone acted dishonestly, but because there may be a sentence in the contract or the term in the contract that meant two different things to two different people. Unfortunately, this can happen far often than most lawyers realize. So, many contract disputes are not caused by bad law, they are caused by unclear drafting. Today, we're going to look at what I believe is the single most important principle in contract drafting, which is clarity. Whether you are drafting an NDA, a master service agreement, or an AI license agreement, clarity is the foundation of a very well written agreement. And you can ask why this matters, because in most cases, clients they rarely complain because a contract is too short. They complain because the contract failed to protect them. So good drafting isn't about sounding intelligent, but it's about communicating legal rights with precision. Every extra ambiguity increases legal risk. Every unclear sentence creates room for disagreement. So, your role as a commercial lawyer is to eliminate uncertainty before it becomes a litigation. So, a strong contract is not made by long sentences, unnecessary legal jargons, or vague qualifier. As you can see from the example on the left, I can read it out. Vendor shall provide reasonable support. This is a vague qualifier because it doesn't specify the details, even though it may sound acceptable. For example, support by telephone, by email, what hour, which days, for how long. The specifics are absent, and it can make the contract harder to understand, negotiate, and harder to enforce. But if you see on the right side, there are specifics given, making the term clear for the parties to understand and to negotiate and to enforce the contract. So the clause on the right has not made the term longer for the sake of it, but it has made clearer, and more importantly, it has reduced uncertainty. So clear drafting does not just help lawyers, it can help the sales team understand what has been sold, the project managers understand what they must deliver, the finance team to know when the payment is due, or it can even help the judges in the court determine what the parties have actually agreed. Let me ask you something. So, have you ever read a clause twice and still wondered what it actually means? If you have, you're not alone because that's a bad clause. It means that there are multiple interpretations which could eventually lead to disputes. And we need to have good clause, which would mean there is one interpretation and there is predictable outcome. So, an alternate way to look at all the points discussed so far is that ambiguity usually benefits one party. And so, in a negotiation phase, when a party who seeks flexibility, one should know that they often wants vague language versus the party seeking certainty, that party would want precise language. So, your job as a commercial lawyer is to understand where precisions create value and where flexibility is commercially appropriate. On that note, as a professional, we must be able to recognize unclear drafting, you know, unclear commercial clauses, try to reduce potential negotiation disputes, and improve the enforceability of the terms and condition in the agreed contract. Understanding scope question is relevant to the topic that we are discussing today, and the terms and condition that you draft must answer the scope questions. So there are generally five questions every term and condition must answer. So I have listed the five questions which are specifically relevant to the topic that we are discussing, and we need to answer these five questions to understand or to ensure that the business deal that the parties are trying to close are in the right direction. And these five questions are relevant in most crucial clauses, including scope of the services, obligations, performances, payment, and liabilities as such. So, if your clause cannot answer these questions, your draft is not complete. For example, a simple example is, before long, the customer believes all of the specified terms are included in the agreement, whereas the vendor believes they are additional services. Another example is given in the slide here. If you're acting for a software company that has agreed to develop a customer portal, and the contract says that vendor shall develop a customer portal, but this is pretty straightforward while not answering those five questions. And the list of the items given out here will show that the draft is not complete. So you can easily determine a draft is poor when it doesn't answer those five questions: who, when, why, how, and what if it doesn't perform. So a poor draft would be when the services are not defined, the limits are not defined, there are no process guidelines provided in the draft. Let's discuss an example out here. So a poor draft would be, in quotes, vendor shall provide implementation services. This does not define the services in terms of the scope or the limitation. We need to improve the poor draft into a better draft by giving specifics, like mentioning what kind of implementation services are there, up to what extent it will be provided, and if there are any additional services, would there be included in the services, or would there be additional change request? you know so you can try examples for yourself. I have listed out one out here. Try where you can try drafting a website development. You can write what kind of deliverables, what kind of customer responsibilities, what kind of exclusion from the services. By developing such questions, you would understand why the scope questions are important and how you can draft commercial contracts effectively. Unclear language will lead to unclear scope, which would eventually lead to unclear responsibilities, obligations, rights, and liabilities arising from the contract. So, when the scope is vague, every other clause, for example, payment, acceptance, testing, in IP rights in a tech contract, would become more difficult to apply. Let's elaborate on this. So, when there is a data breach, if your draft doesn't answer who's the sole owner of the breach, where has it happened, on whose platform, whether the vendor or the client or the customer, and what kind of activities were carried out when the data breach happened. If the draft doesn't answer this, that means the draft is unclear about the rights and obligations or the liabilities of the parties in the contract. Similarly, in another example, if the scope of work or services is not clear, there would be potential conflict between the parties. For example, if there is a content writing services where the work is based strictly on specification and the client wants revisions, in such case where the draft is absent of additional work compared with revisions where it's free, this will lead to potential conflicts between the parties. So, modifications of revisions of work not mapped with a defined scope would lead to production and delivery issues, which would eventually cause payment and delivery issues. So, because of the potential conflicts and problems, experienced commercial lawyers spend so much time in defining it carefully. So, they stress on the specifics and ensure that every scope questions are answered. For example, they stress on what is being delivered by describing the goods and services. They stress on the party who should be responsible for specific tasks, such as who installs the software, who provides training. They particularly focuses on scope changes in cases where timeline changes, business priorities evolve, and whether there is some control mechanism to monitor changes and deviation from the original specification. They also focus on when, in terms of the milestones, which is also tied with payment commencement. Um, they focus on implementation and schedule. They also focus on the question where, in terms of where the services would be provided, where the platform would be located. It will be on site or off site. Will the services be provided through a cloud platform? All these specifics tied with these questions are necessary, and for that, they need to bring clarity as to the rights, the liabilities, the obligations, and prevention of any disputes between the parties. So let's discuss some examples where ambiguity could cause risks of frequent disputes. For the sake of the topic, we'll take deliverables, non-compliance, change control requests, and rights, obligations, liabilities, and limitation. These clauses appear in almost every commercial agreement, whether you are drafting an NDA, an MSA, software development agreement, or a procurement agreement. And if the provisions in the agreement are not drafted properly, the contract becomes significantly more difficult to perform and enforce. So let's jump to blur deliverables. For example, if there's an agreement for manufacturing t-shirts and the terms are not clear as to the quality of the color or the fabric raw material, the deliveries will be affected. Second point is when the draft doesn't offer clear terms as to the consequences of non-compliances, potential legal, business, or financial risks will arise and affect the parties. So, if the draft doesn't offer consequences as to when a breach happens, including who's responsible, where it happened, whose fault was it, there would be consequences as to the sensitive information as well as rights and liabilities of the parties. Similar consequences would happen to breach of confidential obligations or mitigating measures and remedies, which can expose the parties and the whole business dealing to risks, for example, market risk, reputational risk, or loss in their competitive elements of their businesses. Now let's go to the example of change control. The example discussed earlier about content writing services and differences between modification and additional services are relevant here. So ambiguity you can see in change control where there is inadequate processes or guidelines. For example, unclear guidelines as to handle urgent requests versus the standard request in terms of the delivery, the price changes, etc. and ambiguity as to the terms that could trigger the processes of handling the changes, and who will be responsible, and the expertise that will be required in handling urgent changes or standard changes. Now, regarding the examples of rights, obligations, liabilities, and limitation, there could be ambiguity in terms of the extent or the limitations of the remedies uh, connected to the parties. For example, ambiguity could be found in remedies of warranty as to whether there is refund, whether there is repair, whether there is termination, or combination of all these three. So if you see the example on the right, the clause provides clear-cut certain remedy to the customer to get remedied by the service provider as to in case of a defect or error in the services, the customer will have remedy to get the defect corrected at the expense of the service provider. As a concluding note, I would like to say that it's a good practice to ask or clarify with the client, because there could be areas, in addition to the areas discussed, such as unfamiliar terms related to the business or trade, specific conditions or deal, specific issues the client wants to protect, interests or things they are essential, or previous and existing draft to compare and streamline. And thank you again for joining. I hope this session has been helpful, and we'll see you again soon.